Marjorie Taylor Greene, is she constitutionally qualified to hold political office? Well, according to some of the citizens in her district, the answer is no. Well, a federal judge has sided with those citizens, saying that the lawsuit that says Marjorie Taylor Greene should not hold political office because of her insurrectionist act or giving aid and comfort thereof, because of that, well, this lawsuit actually has merit. Let me give you some background to this, all right? So a federal judge has now ruled that a group of Georgia voters can proceed with legal action seeking to disqualify United States Representative Marjorie Taylor Greene from running for re-election to Congress, citing her role in the deadly attack on the US Capitol. Now, you may say, what was her role? And how does this disqualify her based on the Constitution? I'm going to give you all of those details. The challenge filed last month with the Georgia Secretary of State's office alleges that Greene, a Republican, helped facilitate the January 6, 2021 riot and disrupted Congress from certifying Joe Biden's presidential election victory. That violates a rarely cited provision of the 14th Amendment and makes her ineligible to run for re-election, according to the challenge. Now, I'm going to be critical of the challenge just for a moment, okay? The challenge, in my opinion, should have focused on her giving aid and comfort rather than her planning or being involved in the attack. I think this was a strategic mistake by the attorneys, but I will give you the premise for my conclusion as I continue. The amendment says no one can serve in Congress who, having previously taken an oath as a member of Congress to support the Constitution of the United States, shall have engaged in an insurrection or rebellion against the same. This was ratified shortly after the Civil War. It was meant, in part, to keep representatives who fought for the Confederacy from returning to Congress. So basically, this was a very, very small group of people who would even qualify under this amendment, which means they literally created a constitutional amendment for a particular individual that they did not want to unravel the government. Sounds smart. It was a good idea, actually, because individuals who are part of the Confederate, they committed treason. They were adversarial to the United States of America. We do not treat them as individuals who committed treason. We honor them in America. We give them street names and we name highways after them. It's utterly insane, but they did commit treason, okay? So they said this provision will stop those people who committed treason from trying to do it again through official government power. What do you see today? You see individuals who attempted to overthrow the United States government commit an act of treason, seeking and obtaining political power. There's more. Greene, 47, Marjorie Taylor Greene, 47 years of age, filed a lawsuit earlier this month asking a judge to declare that the law that voters are using to challenge her eligibility is itself unconstitutional and to prohibit state officials from enforcing it. Now, here's the great irony of her argument. She's arguing that the Constitution is unconstitutional. That is her argument. Her literal argument is that the 14th Amendment, Section 3 of the US Constitution is in fact unconstitutional. Judge Amy Totenberg, who's been in the news before for voting rights issues, siding on the right side, in a 73-page ruling denied Greene's request for a preliminary injunction and temporary restraining order. Greene said in her lawsuit that she vigorously denies that she aided and engaged in insurrection to obstruct the peaceful transfer of presidential power. Now I'm going to show you a video from Newsmax, an ultra-conservative news outlet that provided cover for Marjorie Taylor Greene. Look at how they contextualized it. Here it is.
brought this case against her using the 14th Amendment, which was actually enacted after the Civil War to bar Confederates from running for Congress. The amendment says no one can serve in Congress who, having previously taken an oath as a member of Congress to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same.
Or rebellion against the same. That's where the journalist stopped. I'm using the terminology journalist loosely. But here's the part the journalist left out. Shall have engaged in insurrection or rebellion against the same, or, not and, or given aid or comfort to the enemies thereof. Given aid or comfort to the enemies thereof. That's in the Constitution. That's Amendment 14, Section 3. It doesn't stop with being involved in the insurrection. It also says if you have given aid and comfort to those who were. Isn't that interesting? Well, why was that provision written? Because the individuals who wrote that amendment, they were well aware if they did not include that amendment, then the friends of those who committed treason would simply run for office and do their bidding for them. And they said, okay, if you provided aid for these individuals, you cannot qualify for public office. You cannot seek public office. You gave aid and comfort thereof. This is very simple, nothing complex about it, okay? Marjorie Taylor Greene went on record about this. She talked to none other than Little Tuck Tuck. Here it is.
And now the progressives, the people that donate to dark money groups, the 501c3s and the foundations, they've hired up some attorneys from New York who hate the people in my district and don't believe that they should have the right to elect who they want to send to Washington, which is me. I have overwhelming support in my district and I'm so thankful for all of them. Well, now they filed a lawsuit because they're trying to rip my name off of the ballot and steal my district's ability to reelect me and send me back to Congress.
Well, you should have thought about those things before you provided aid and comfort to those that committed insurrection against the United States government. You should have thought about the Amendment 14, Section 3. So let's be very clear about all of this. Here's why the case is more important even than Marjorie Taylor Greene. Marjorie Taylor Greene is important, but there's a bigger application here. Because if this is successful against Marjorie Taylor Greene, then by legal theory, by established federal case law, it can also be successful against Donald Trump. But here's the great irony of it. Section 14, Article 3 has always been here. Why is it that it took citizens to file this lawsuit, to hold accountable Marjorie Taylor Greene and others? Why are citizens leading a fight that should be led by the administration? Why is the Department of Justice not saying this? Why is Biden not saying this? Citizens literally are showing more courage than the entire government in power right now. A.B. thoughts?
Yeah, so I think this particular amendment, Little Miss Marjorie, you fall directly into that, right? What we do not want are people in Congress who don't even understand the Constitution, because that's the basis of your position. That's the basis of your job. You need to understand the Constitution and how it works. So if you don't know that, then you don't qualify for your job, period. So it's time for you to go. But you did take the words right out of my mouth. Citizens are standing up in a way that our government should be, in a way that this is why we voted in the government officials that we have, so that you can protect your citizens. So I'm glad that they're doing this. And let's also not be fooled by Little Miss Marjorie's language, right? While she's saying we're ripping her opportunity to be reelected and we're stealing from her, just like y'all ripping people voting rights and stealing people's ability to be able to vote in your exact state. So you know what, Marjorie, you fall in line, learn the Constitution, and then when you get there, come try out for your job again. But I absolutely think she should be removed and should not be able to run.
And it is interesting because she's going on multiple outlets defending herself, which means she's afraid. She did not simply release a statement from her office. She did not just release a social media video saying, hey y'all, this is wrong what they're doing to me. Let me raise some money, okay? She's actually working to build a case so that she's not removed, which means she is in fear that this could happen. What are your thoughts on that?
No, I agree, right? They always say a hit dog will holler, right? So she's trying to get in front of it, but she obviously doesn't have good lawyers, because a good lawyer would tell you to shut up, be quiet, right? Let us handle this in a court of law the way we're supposed to. So this is how you know she doesn't have a case. So now she's trying to prove her case in the court of public opinion, but I don't think she has as much support as she might want to try to convince us she does. So with that being said, again, bye, Marjorie.
Yep.